Hello, everyone, and welcome back. Before we continue on, I will remind you again that I am not a lawyer. I'm not a labor lawyer. I'm not certified to practice law in Vietnam. I'm just simply some foreigner from the United States who knows about the labor code. So, moving on, we're going to go ahead and continue on with what we talked about earlier, and we're going to move on because it was technically a part A and part B. And I guess this is more the part B. I guess I'm going to go ahead and rename this to part B because it's basically a continuation of what we were talking about earlier. So, moving on. Article 40 Obligations of employees when unlawfully unilaterally terminating a labor contract. So, what happens if the employee decides they want to terminate their contract and it's not legal? Well, this is what will happen. Now, again, this is the English version, it's the Vietnamese version. The English version is just for reference. The Vietnamese version is the one that you really need to pay attention to. So, Article 40 Now, the employee who illegally unilaterally terminates his or her employment contract shall not receive a severance allowance. You don't receive any severance allowance at all. And we'll get to that later on. Clause 2. Pay the employer a compensation that is worth his or her half a month's salary plus an amount equal to his or her salary for the remaining notice period from the termination date. That means the employee must pay the employer at least half a month of their salary plus an amount equal to his or her salary for the remaining notice period. So, essentially, if you quit your job, it's found to be illegal, you have to go ahead and pay your employer half of a month's salary. So if you have $40 million a month, you have to pay the employer $20 million plus the time of the remaining notice period from the termination date. So if you're supposed to give 30 days, you quit, it's found to be illegal, you have to pay them plus 30 days. Now, if you quit halfway through, like say you go ahead and, you give them a notice and then you quit, yeah, you have to go ahead and give them the remaining notice. So, yeah. Moving on. Clause 3. The employee shall reimburse the employer with the training costs in accordance with Article 62 of this code. We will go ahead and talk about that later on. So essentially, if you unilaterally terminate your employment contract and it's found to be illegal, you have to do all this. So, yeah. Moving on. What happens when the employer unilaterally terminates the employment contract? Well, that's a good one because, see, I keep talking about what happens to employees, but what happens to the employer? Well, this is what happens. Article 41 Illegal unilateral termination of the employment contract by the employer. The employer, Clause 1, the employer that unilaterally terminates an employment contract with an employee shall reinstate the employee in accordance with the original employment contract and pay the salary, social insurance, health insurance, and unemployment insurance premiums for the period during which the employee was not allowed to work, plus at least 2 months' salary specified in the employment contract. So, on top of all this, if the employee makes $40 million a month, they must not only reinstate the employee but give them 80 million dong and then allow them to work. After reinstatement, the employee must return the severance allowance or redundancy allowance, if any, to the employer. Where there is no longer a vacancy for the position or work as agreed in the employment contract and the employee still wishes to work, the employer shall negotiate revisions to the employment contract. When the employer fails to comply with the provisions on notice period in Clause 2, Article 36 of this labor code, the employer shall pay a compensation that is worth the employee's salary for the remaining notice period from the termination contract. Now, here's the thing. Clause 2, Article 36. So what that references is immediate termination without notice. I think. Let's go ahead and look at it again. Article 36, Clause 2. Yeah, I know. I was literally just right there, and then it just bumped it out. Clause 2. Article 36, Clause 2 is right here. When unilaterally terminated the employment contract, like here, if they have to notify you, then that's what that means. If they have to notify you, that's what that means. So they need to pay compensation that's worth your salary for the remaining notice period. Now, Clause 2, moving on up. We have a lot of stuff to talk about, not a lot of time to do it in. Clause 2, in case the employee does not wish to return to work, in addition to the compensation prescribed in Clause 1 of this article, the employer shall pay a severance allowance in accordance with Article 46 of this code in order to terminate the employment contract. So they must pay severance allowance in case the employee does not wish to work. Now, Clause 3, where the employer does not wish to reinstate the employee and the employee agrees, in addition to the compensation mentioned in Clause 1 of this article and the severance allowance mentioned in Article 46 of this labor code, both parties shall negotiate an additional compensation which shall be at least 2 months' salary under the employment contract in order to terminate the employment contract. So essentially what happens is the fact that if the employer does not wish to reinstate the employee agrees, then you get compensated once in Clause 1, you get compensated again because of Article 46, and you will have at least 2 months' salary. Now, let's see. Changes to structure due to technological reasons. Let's see. Due to technological reasons. I don't think this really applies to English teachers because this looks like this is pretty much more of a industrial workers kind of thing. And same for Article 43, labor utilization plan. And yeah, we don't need that. Okay, so Article 45, we're going to go ahead and talk about that one. Again, if you want to learn about the labor laws that I don't talk about, you could do that on your own time. So Article 45, noticing the termination of employment contracts. The employer shall send a written notice to the employee of the termination of his or her employment contract, except for the cases specified in Article 4, 5, 6, 7, 8, Article 34 of this labor code. So if you're being terminated due to disciplinary reasons, technically, let's see, Article 4, 5, 6, 7, and 8. So Article 34, 4, 5, 6, 7, and 8. So 4, 5, 6, 7, and 8. The employee is dismissed for disciplinary reasons. So if an employee is dismissed for disciplinary reasons, then, come on, let's get back up there. If an employee is being dismissed due to disciplinary reasons, then 46, 45. Yeah, if they're being dismissed for disciplinary reasons, you need to send a written notice, except for the cases specified here. Technically, for Article 8, disciplinary reasons, you do not need to send a written notice. All right, so moving on. Clause 2, in case an employer that is not a natural person shuts down business operation, the date of termination of the employment contract is the same date of the notice of business shutdown. In case the Provincial Business Registration Authority issues a notice that the employer does not have a legal representative or a person authorized to exercise the legal representative's rights and obligations, according to Clause 7, Article 34 of this labor code, the date of termination of the employment contract is the same date of the notice. So that's that. So for article, so like Clause 10, this means they must send you a written notice. Remember Clause 10 of Article 34, which is, let's see, Clause 10, the employer unilaterally terminates 4, 5, 6, 7, and 8. So they do not need to do that. They do if they want to unilaterally terminate your contract and it complies with Article 36. If the employee does, then you should give them a written notice. So moving on, number 36. That's my thing telling me I need to resubscribe. So we got the severance allowance. Again, this is not something that evil English centers and most employers would want you to know about. So moving on. Article 46, severance allowance, Clause 1. In case of an employment contract is terminated as prescribed in Clauses 1, 2, 3, 4, 6, 7, 9, and 10, Article 34 of this labor code, the employer is responsible for paying a severance allowance to the employee who has worked on a regular basis for a period of at least 12 months. Each year of work will be worth a half-month's salary, except for the cases in which the employee is entitled to receive retirement pension as prescribed by social insurance laws, and the cases specified in Point E, Clause 1, Article 36 of this labor code. Clause 2. The qualified period of work as the basis for calculation of severance allowance shall be the total period during which the employee actually worked for the employer, minus the period over which the employee participated in the unemployment insurance in accordance with the unemployment insurance laws, and the period for which the severance allowance or redundancy allowance has been paid by the employer. So that's that. Moving on. Now, Clause 3. The salary as the basis for calculation of severance allowance shall be the average salary of the last 6 months under the employment contract before the termination. Clause 4. The government shall elaborate this article. Now, redundancy allowance. That doesn't really apply to English teachers and stuff like that. So, yeah. Now, responsibilities of the parties upon termination of an employment contract. That is something I'm going to talk about. Now, here again, this is something that a lot of bad English centers don't want you to know about, so pay attention. Responsibilities of the parties upon termination of an employment contract. Within Clause 1, within 14 working days following the termination of an employment contract, both parties shall settle all payments in respect of the rights and interests of each party. In the following cases, such period may be extended but shall not exceed 30 days. Shutdown of business operation of the employer that is not a natural person, subclause A. Subclause B. Changes in the organizational structure, technology, or changes due to economic reasons, subclause C. Full division, partial division, consolidation, merger of the enterprise, sale, lease, conversion of the enterprise, transfer of the right to ownership or right to enjoyment of assets of the enterprise or cooperative. Subclause D. Natural disasters, fire, hostility, or major epidemics, such as COVID-19. Now, Clause 2. So what this means, Clause 1 is simple. Within 14 working days, they must go ahead and settle all payments. All payments. That means if you owe them money, you need to pay. If they owe you money, they need to pay you within 14 days, but shall not exceed 30 days in cases of epidemics such as, COVID-19. Moving on. Clause 2. Right there. Clause 2. Priority shall be given to payment of the employee's salary, social insurance, health insurance, unemployment insurance, severance allowance, and other benefits under the collective bargaining agreement and employment contracts in case of shutdown, dissolution, or bankruptcy of an enterprise or cooperative. Now, that has to deal with union workers and industrial workers and stuff like that. So, moving on. Clause 3. The employer has the responsibility to complete the procedures for verification of duration of participation in social insurance and unemployment insurance, return them and original copies of the employee's other documents, if any. Now, they shouldn't have any of your original documents at all. So, let's move on. Subclause B. Provide copies of the documents relevant to the employee's work if requested by the employee. The employer shall pay the cost of copying and sending the documents. The employer shall pay the cost of copying and sending the documents. So, yeah, that is subclause 3 upon termination of an employment contract. Now, what is an invalid contract? Well, this actually talks about the employment contract itself, which I think is going to be more about the next topic of conversation of what we're going to go ahead and get into. Because I've already told you about how to quit your job legally. So now I'm going to go ahead and continue that and basically start talking about contracts, what's a contract, what you're supposed to look for, what you're not supposed to find, stuff like that. So I guess that's what we're going to do now. All right, so Section 4, Invalid Employment Contracts, Article 49, Invalid Employment Contracts. An employment contract shall be considered invalid in the following cases. The entire contents of the employment contract are illegal. Subclause B. A person concludes the employment contract contains ultra vires or against the rules for employment contract conclusion specified in Clause 1, Article 15 of this Labor Code, which means that the contract must be concluded in good faith and honesty. So, yeah, if it was not concluded in good faith and honesty, was not, it's invalid. So this means if your employer lies to you, it's considered invalid. Subclause C, the work described in the employment contract is prohibited by law. So if they want you to do anything illegal, like, work overtime and then not pay you, that's illegal. Clause 2, an employment contract shall be partially invalid when parts of its contents is illegal but does not affect its remaining contents. Now, who has the ability to invalidate employment contracts? That's the People's Court. Shall be entitled to invalidate employment contracts. Now, settlements upon invalidation of an employment contract. So, when an employment contract is declared as partially invalid, it shall be dealt with as follows. This is Article 51. I just mentioned Article 50, competence to invalidate employment contracts. We're moving on to Article 51. We have about 9 minutes and 30 seconds left, so let's see how fast we can get through this. So, settlements upon invalidation of an employment contract. When an employment contract is declared as partially invalid, it shall be dealt with as follows. Subclause A. The rights, obligations, and benefits of the parties shall be settled in accordance with the collective bargaining agreement or provisions of the law if there is no collective bargaining agreement. Subclause B. The parties shall revise the invalidated part of the employment contract in accordance with the collective bargaining agreement or labor laws. Clause 2. In case an employment contract is completely invalidated, the rights, obligations, and interests of the employee shall be settled in accordance with law. In case an employment contract is concluded ultra vires, another contract shall be concluded, and the government shall elaborate this article. Labor dispatch. We don't need to talk about that. All right, cool. So we got about 8 minutes left, so we're going to talk about other parts of the employment contract. Let's go ahead and go back up to, let's see. We already talked about that. Since we're talking about employment contracts already, we should already go through the contract itself before I go ahead and tell you about some other stuff. So let's see. Okay, so employment contracts. Excuse me. Let's see. Types of employment contracts. Yeah, we're going to go ahead and go up here to conclusion of an employment contract. I have about 8 minutes left, and I have absolutely no water to drink, so I might start coughing here in a couple minutes due to lack of water. I had to push this video out before my time limit on my free software expires. Sweet, no water. Okay, cool. Let's see what we can do with this. Excuse me. I should go ahead and tell you guys that cough warning in this one. All right, so Article 13. Let's go ahead and get through this together, shall we? All right, here we go. Employment contract, Chapter 3, Section 1, conclusion of an employment contract. Employment contract. An employment contract is an agreement between an employee and an employer on a paid job, salary, working conditions, and the rights and obligations of each party in the labor relations. A document with a different name is also considered an employment contract if it contains the agreement on the paid job, salary, management, and supervision of a party. What this means is that if it's called like a teacher job offer or, something else, it doesn't specifically say employment contract, it's still an employment contract if it has all that stuff on it. Clause 2. Before recruiting an employee, the employer shall enter into an employment contract with such employee. So, yeah, you need a contract. Now, forms of an employment contract. Article 14. We have about 6 minutes and 40 seconds left. An employment contract shall be concluded, Clause 1. An employment contract shall be concluded in writing, and made into 2 copies, one of which will be kept by the employee, the other by the employer, except for the case specified in Clause 2 of this article. An employment contract in the form of electronic data conformable with electronic transaction laws shall have the same value as that of a physical contract. So if it conforms with these laws, it means it's still valid. Now, Clause 2. Both parties may conclude an oral contract, means verbal, with a term of less than 1 month, except for the cases specified in Clause 2, Article 18.A, Clause 1, Article 145, and Clause 1, Article 162 of the Labor Code. Now, remember earlier, it mentioned Article 15, Clause 1. This is what it means. Principles for conclusion of an employment contract, right here. Voluntariness, equality, good faith, cooperation, and honesty. Now, I can tell you that 99% of the English centers out there are not honest. They don't cooperate. They don't do anything in good faith. They don't treat you equally. And, well, voluntary is just a word to them. They don't understand what it means. Now, for the good English centers out there, yes, they obviously do understand what this means. That's why they're still in business, because they understand. There are good English centers out there, and I know there's good English centers out there, but I've never met one. Now, Clause 2, freedom to enter into an employment contract which is not contrary to the law, the collective bargaining agreement, and social ethics. social ethics. Pay attention to that. So, Article 16, obligations to provide information before conclusion of an employment contract. We have less than 5 minutes to go. Article 16, obligations to provide information before conclusion of an employment contract. Clause 1. The employer shall provide the employee with truthful information about the job, workplace, working conditions, working hours, rest periods, occupational safety and health, wage forms of wage payment, social insurance, health insurance, unemployment insurance, regulations on business secret, technological know-how, and other issues directly related to the conclusion of the employment contract if requested by the employee. Please remember this. Ask your employer a bunch of questions. I honestly hope you actually remember this and ask them everything, because the more questions you ask, the better off you are. Now, Clause 2. This is where you become involved. The employee, that's you, shall provide the employer, your boss, with truthful information about your name, your date of birth, your gender. Now, LGBT people, if you are recognized as transgender, like female to male or male to female, and you are recognized as your gender that you have chosen, then you must be truthful with the gender you have chosen. So if you're female to male, you identify as male, you are male. If you are male to female, you identify as female, you are female. That's what that means. Your residence, where you live in Ho Chi Minh City, what district you live in, stuff like that. Educational level, do you have a bachelor's degree? Do you have college trade certificates? What kind of education do you have? Occupational skills and qualifications. This means your CV, your health conditions, such as high blood pressure or eye problems, and other issues directly related to the conclusion of the employment contract, which are requested by the employer. So if your employer knows about these kind of questions, they can ask you, and you must answer them truthfully. Now, I also went ahead and talked about Article 17 earlier, and we're going to go ahead and talk about that too. This is one of the big ones. If you haven't paid attention for some of my series, you really should pay attention now. Article 17, prohibited acts by employers during conclusion and performance of employment contracts. Keeping the employee's original identity documents, diplomas, and certificates. If your English Center does this, or if your job in general does this, it's illegal. Demand your stuff back right now. Get your stuff back. Get police if you have to. They are not allowed to keep your stuff. Get it back. Clause 2, requesting the employee to make a deposit in cash or property as security for his or her performance of the employment contract. Meaning, if your boss wants you to pay them for you to work, no, that's not how that works. Clause 3, forcing the employee to keep performing the employment contract to pay debt to the employer. Now, that is also considered, definitely forced labor. So, can't do that. We have less than a minute left. So, Clause 18, competence to conclude employment contracts. Now, here's the thing. I'm going to talk about this one real quick and then probably going to cut the video short. Article 18, competence to conclude employment contracts. Clause 1, employees may directly conclude their employment contracts except for the cases specified in Clause 2 of this article. Clause 2, in respect of seasonal works or certain jobs which have a duration of less than 12 months, a group of employees aged 18 or older may authorize the representative of the group to conclude the employment contract, in which case such employment contract shall be effective as if it were separately concluded by each of the employees. The employment contract concluded by the said representative must be enclosed with a list clearly stating the names, full names, ages, genders, residences, and signatures of all employees concerned. Clause 3. The person who concludes the employment contract on the employer's side shall be the legal representative of the enterprise or an authorized person as prescribed by law. The head of the organization that is a judicial person, I think they meant to say judicial person, or an authorized person as prescribed by law. C. The representative of the household, cartels, or an organization that is not a judicial person or an authorized person as prescribed by law. Now, cartel, I don't know what they meant by that, but obviously not evil. So let's just move on. Letter D. The individual who directly hires the employee. Clause 4. The person who concludes the employment contract on the employee's side shall be the employee himself or herself if he or she is 18 years of age or older. The employee age 15 to under 18 with written consensus by his or her legal representative. The employee age under 15 and his or her legal representative. The employee lawfully authorized by the group of employees to conclude the employment contract. And the person who is authorized to conclude the employment contract must not authorize another person to conclude the employment contract. So you can't, sub-authorize. That's what that means. Now, we're going to go ahead and scroll up. Now, entering into multiple employment contracts. We have less than, looks like we've already stopped. So we got to go ahead and get into this quickly. All right, dismiss. All right, cool. So entering into multiple employment contracts. I'm already done with this, but I got to, say this anyways. Okay, so I'm going to go ahead and stop the video here because it's already at the 25-minute mark. So I'm going to start the video here next, the next one, and then we're going to move on with talking about more about the employment contract itself before I talk about some odds and ends of the labor code that you need to know. So going back to my video, I am going to go ahead and tell you all that if you like my videos, please like, share, subscribe, and comment. If you wish to donate, please go ahead and get in touch with me on Gmail at tuxedoshadow@gmail.com, either by email or by Google Chat. Also, please go ahead and, if you want to send me a cash tip or a cash donation, whatever you want to call it, again, get in touch with me there, and I'll give you instructions on how to do it because I have an international bank account. If you want to go ahead and send me a money order, if you're from the U.S. and you want to send me a money order, I accept those too. Like MoneyGram, Western Union, stuff like that. I accept those too. If you want to send me goods or services, please let me know, and I'll be more than happy to accept it. Now, the reason why I teach people the labor code is pretty simple. It's like I said before, I got taken advantage of a lot, and it wasn't until I learned the labor code that I learned exactly how badly I was being taken advantage of. I don't want that to happen to anyone else. That's the reason why I'm doing what I'm doing. So, I hope you all have a good day, and I hope to see you all again in the next videos. Peace.